All right, first thing, is this thing on? Okay. Now, how does a kid from Southern California, from a beach community, who played a lot of soccer, get to be called the marijuana guru? I do not understand. I feel like I've been profiled. All right, so our topic this morning is not cats. It is marijuana in the workplace. And what I think we really mean by marijuana in the workplace is our drug policies and marijuana. How do they interact? What can we do? Now, this used to be an easy thing. It used to be that you'd have a drug and alcohol policy, and there's a fairly clear spectrum. On one side, you'd have your PCPs, your LSD. These were all prohibited, violation of the policy. Then on the other side, you've got things like aspirin, clearly not a violation of a policy. And marijuana used to be comfortably on the PCP, LSD side. But now, it's kind of called into question a bit. So we're going to talk about that. And our agenda this morning is going to be a little bit non-traditional because I'm going to spend a little time talking about sociology and economics. And then we're going to move into con law, constitutional law. And then we'll finally get to the medical marijuana statutes, the personal use statutes, and then drug and alcohol policies. Now, one other thing I'll tell you, I know that I think Adam may have said no questions. For my program, if you have a question and you want to stop me and you want to ask it, go right ahead. I'm all about questions. So anytime I say something that triggers a thought, feel free to ask it. So let's just take a look at our landscape here. This is not a current map of marijuana laws. This is from last year, so it's already outdated. Illinois, for example, has a pilot medical marijuana program. So there are marijuana laws, cropping up all around the country, and that presents challenges for us. Now, to understand marijuana in the workplace, I think we need to understand the people in the workplace. And we need to understand the culture from which they come. Now, I go back to the 70s, as I mentioned, Southern California, soccer community. Cheech and Chong, had a series of very popular drug culture movies. I never saw any of them. The words Cheech and Chong were not spoken in the McClory household. It was just verboten. But they were quite popular and reflective of a certain segment of the culture. And in the intervening years, since the 1970s till now, the acceptance of marijuana has grown quite broad. I mean, we've got for goodness sakes, we've got a cookbook, a holiday cookbook that's pot-based. And we've got a popular TV show in which I never saw Weeds either, but I think it was about a stay-at-home mom who was trying to make ends meet, and she had some kind of a pot business out of her house. So marijuana in the culture is expanding. What does that mean in your workplace? Is marijuana in your workplace? I think the answer is yes. I don't know what it is about Cheech and Chong, but I've got another Cheech and Chong picture up there to illustrate that, employees who drive to work, some of them, are regular users of marijuana. You've got marijuana vending machines. Now, this is not actually in a workplace break room. I found this in, let's see if I got the name of this magazine right, Cannabis Business Executive Magazine. There is such a magazine, so there's a segment out there that there's enough circulation to have such a magazine. But these machines for now are in licensed marijuana shops. But the idea is that, people are thinking about vending machines. And then I was kind of goofing around when I was making this up, and I thought, what about at potlucks, just because the word pot. So I did a Google search, and there actually was a case in which a teacher to a potluck, brought marijuana-laced something, and people got sick, she got arrested. But the idea is marijuana is in the workplace, employees, potential employees are exposed to it, and, some are using. So, now if you've been reading our blog, and I think Adam may have mentioned that I do our Bullard Edge blog, one of the topics that I've hit upon over the course of, I think we've done 7 or 8 blog posts on marijuana, is economics. And, my theory, not everyone agrees with me, but my theory is that money will drive marijuana to, some form of acceptance. Many of the projections out of Colorado and also out of Washington State have been that the tax dollars will be ginormous, and some of the projections were astoundingly high before the laws went into effect, the personal use laws in those states, and the actual tax revenues, I think, have fallen short of projections. However, it's not chump change. In Colorado, for the first year, there were $46 million in tax revenue generated, which is small given that the budget for Colorado is $69 billion. But since the money is earmarked to go to schools and other things, that amount of money can go a long way. I know from my work on school district budget committees and school closure committee that just a little bit of money goes a long way. And so there is a lot of there are a lot of hopeful eyes on the marijuana tax dollar. Now, in Washington, which has only had its personal use law in effect since last July, during the first 6 months, they generated about $7.2 million in tax revenues, which will probably go up. And then in Oregon, where we haven't even started personal use yet, but before the election last November, so before the Measure 91 was even passed, a number of local communities were scrambling to enact their own local marijuana tax laws with the idea that they'd be higher than what the measure provided, and that somehow they'd be grandfathered in after Measure 91 got passed. I think that is still an issue. But the whole point of this is that there's a lot of money at play here, and so with that in mind, I'd say marijuana is here to stay. We have a federal law that's different than state laws. We have a whole crazy quilt of state laws that are different from one another. And so this is where we begin the analysis of what do we do about marijuana in our workplaces? How do we maintain some level of control on the workplace? Now, if we go back to the map at the beginning, the normal map, the National Organization of the Reform of Marijuana Laws, which I guess is an aspirational title for them. That's the federal law. And I want to ground our discussion in the supremacy clause out of the U.S. Constitution. which, it's right up there on the board, and it essentially says, boiling it all down, federal law trumps state law or local law. Interestingly, side note, when I was in California working, I was asked to do a law review article because there was a judge in the Oakland area who had written an opinion in which he said that the local law there trumped federal law. And so somebody wanted to get a law review article discussing that issue. So federal law is king, and there are three ways in which federal law can be king. It can either be the result of some express preemption, so you can have something in a federal law that says, this is it, no state laws, no anything. You can have a statutory scheme that is so pervasive that it, what they call, fills the field, so it takes over everything. Or you can have a case of conflict. And I think that's where we are in our analysis here, is we have a federal law, and we're going to see that we have state laws, and there's conflict. And so in that case, federal law is going to prevail. Now, the federal law in question here is the Controlled Substances Act of 1970. And, it regulates a whole variety of substances and organizes them into 5 different types of schedules. And then there are certain rules related to each schedule. Marijuana has always been on Schedule 1, and that includes heroin, LSD, and other types of drugs like that. In the middle of this slide, you see the criteria for placing a substance on Schedule 1, and I think in item B it says the drug or other substance has no currently accepted medical use in treatment in the United States. Now, the medical marijuana statutes, at least the proponents of those, would probably beg to differ, but bear in mind, most of the medical marijuana statutes are voter-generated as opposed to doctor-generated, and the DEA and FDA are working on more of a medical basis. But there is definite conflict with that point. There's a lot of pressure, political pressure, to move marijuana off of Schedule 1, but I think President Obama commented on that, I think it was last week, or maybe it was 2 weeks ago when he was in Jamaica, and he basically said he did not foresee it happening anytime soon. He didn't see any energy in Congress to do that, and I haven't heard anything that would suggest that it's going to move from there either. So now we move to our state medical marijuana laws, and there are 21 states, plus the District of Columbia, plus Guam, that have all varieties of medical marijuana laws. These started in California in 1996, and Oregon, Washington jumped on board 2 years later, and the first, I think it's 10 or so, came pretty quickly. Then there was a big lull, and then in the last couple of years, we've had about 12 or 13 added on to that. Now, why are these state medical marijuana laws important? I think when we talk about our drug and alcohol policies, we run into the question of reasonable accommodation under the ADA and under state disability discrimination laws. Before medical marijuana, you had the ADA and the states all saying that there's no obligation to accommodate the illegal use of drugs. Marijuana was clearly on the illegal side. After medical marijuana, the question became, well, is marijuana now legal? and therefore, do we have to accommodate it? And that's what I'd call the million-dollar question for a number of years. Do the state medical marijuana laws require an employer to accommodate the medical use and to engage in the interactive process as a result? That was an unsettled question for a number of years until California, Oregon, and Washington Supreme Courts, at least for those three states, settled the issue and said that the states or that employers do not have to accommodate the medical use of marijuana. So if you're using marijuana consistent with your state medical marijuana law, your employer does not have to accommodate or tolerate that use, at least in the workplace. It doesn't have to change its drug and alcohol policy or not enforce it as to you. Now, interestingly, the voters, at least my sense of it is, the voters may agree with those Supreme Court decisions because they happened in 2010 in Oregon, 2011 in Washington, and I think California might have been 1999 or 2009 or 2008. But in the intervening years, there's been no push to modify the state medical marijuana laws, to expressly provide for some kind of accommodation. Now, just to take a quick peek at the Oregon Supreme Court case, which was Emerald Steel Fabricators versus Boley, the court there said no obligation to accommodate the medical use of marijuana, and it gave two basic reasons. One, there's nothing in the statute, the Oregon Medical Marijuana Act, that says you must. And then two, the supremacy clause. On the other hand, Washington Supreme Court simply said there's nothing in the Washington Medical Use of Marijuana Act that requires it, and if they had wanted to do that, they could have included it, but they didn't. But Washington did not cite the supremacy clause. Now, just a side note here, I tried to, I'm not a graphic artist. I tried to do Oregon State colors for the Supreme Court, and then Oregon Duck colors in the little box, and then I tried to do Husky colors in Washington and Cougar colors around, but I probably should have just, instead for my whole thing, just used Notre Dame colors for all the good slides and then USC colors for the really bad ones. Adam, any thoughts? All right. Let's get to Measure 91, Oregon's personal use law. This was approved in November. It went into effect 30 days after approval, so in December, but the part that everybody focuses on, which is the permission to use personally, that doesn't go into effect until July 1, so that's coming up in 2.5 months. The Oregon Liquor Control Commission is in charge of it. They're going to worry about taxing, they're going to worry about licensing for sales, and I think that actually won't even get started until 2016. And then they're also going to issue some rules and regulations about personal use. Now, there are a lot of questions that people have about Measure 91. I've tried to hit a few of them here. Who may possess it? Persons 21 or older. How much? And this is very complicated. We've simplified it here. It just says it varies. 8 ounces of usable pot, which apparently is I think it's a little leafy stuff that's all ground up or something. And you can have 4 plants in your home. But if you read the statute, There's stuff about how many beverages you can have that contain it, how many, cookies and cakes, and it gets all very complicated. Is public use permitted? And the answer is no. Although you may possess, in a pocket, up to 1 ounce in public. Now, I took a look at the statute because I was very curious. Does that mean, for example, that someone can have 1 ounce in their pocket and go onto a school ground? And there doesn't seem to be anything in the statute that expressly says that possession on a school ground, by someone who's 21 or older, would be prohibited. So I'm guessing that that may be something that the OLCC addresses in their regulations and rules and interpretations. What does the measure do to our Medical Marijuana Act? And the answer is nothing. They operate in 2 separate worlds, 2 separate laws, 2 separate sets of regulations. So there has no impact on that. Now, can someone, an Oregonian who legally possesses marijuana pursuant to this law, take it across state line? The answer is no. So those are some of the FAQs that may be of interest to you. There's a whole series of FAQs on the, I think it's on the OLCC website. So if you're interested, you can go and they get into a lot of graphic detail. All right, so you're probably thinking, all right, that's all very interesting, but what is this going to do to the employment laws? Which employment laws are changed or modified by Measure 91? And I know you're wondering that, so I have a slide on it. None of them are. It has, Measure 91 will have an impact on your candidates for employment and on your employees, but it doesn't actually change any of the laws that govern employment here in the state of Oregon. So let's take a minute here to talk about federal enforcement. And one of my partners flagged this for me a couple of weeks ago. I hadn't even noticed it, but late in the year, last year, Congress defunded raiding efforts, which means the Drug Enforcement Agency can no longer raid medical marijuana proprietorships or shops that, things that are operating appropriately under state law. It does not mean that marijuana is now legal. That's not what this says at all. It doesn't remove it from Schedule 1. It just simply says that as a matter of enforcement, we're not allowing the DEA to use any of our dollars for that. And there's the quote from President Obama that I mentioned earlier when he said, "I do not foresee anytime soon Congress changing the law at a national basis." He did reference Colorado and Washington and said, well, those are kind of experiments. We'll see how they go. And I think he's envisioning it taking a number of years, long after he has left office, before Congress might consider looking at that. All right, now how about we switch it up a little bit? Let's do a quiz. And I'm going to be, I'm the I in this, so I'm interviewing somebody named Nate Puffer, who's applying for a clerk position. We'll assume, for this audience, we'll assume it's a public sector employer. Now, during this interview, I'm looking at him, and I think I recognize him, and eventually I remember, oh yeah, he's the guy who was on KSMK TV talking about medical marijuana. And what he said during that interview was, when he was asked whether he used, all he said was, all I can say is that I love having a card. So I know that our drug and alcohol policy allows for testing only on reasonable suspicion. You know, we're public sector employers, so we can't do pre-employment testing unless we've got public safety or special circumstances involving children. So the first question, can I ask Nate why he has a medical marijuana card? How many people think it's yes? Let's see, show of hands. Let's see, one. Anyone else? Two? Can I get three? No? Okay. I'd say the answer is no. This is a trick question. If I ask Nate why he has a medical marijuana card, I'm pre-offer of employment asking for medical information, which the ADA and Oregon state law bar me from doing. Now, I may well know that or suspect that he is someone who uses marijuana, and I may suspect that because of that he has a disability. The most I can do is I can tell Nate what the duties of the position are and ask him if he'll be able to perform the duties of the job. I can also let him know that we have a drug and alcohol policy and that all employees are expected to comply with it. But that's about as far as I can go with him. Now, what about second question? Can I require, following our policy, that Nate be drug tested post-offer? What do you think?
You haven't said there's a policy.
Pardon?
You haven't stated that there's a policy.
Oh, I have, yes. Our drug and alcohol policy allows testing on reasonable suspicion.
You haven't determined as reasonable suspicion.
Okay, so you would say no.
Yes.
No reasonable suspicion, no test. And public sector, so there's just no blanket pre-employment test. Anyone else have? Yes, in the back.
You can require the test, I believe, if you require it upon offense and it's related to the possession.
Okay.
We're all post-offer, similar to law enforcement.
And that's what I meant. You said you got reasonable suspicion, but you don't have listed that there's a pre or post-offer or anything else in your information.
Oh, well, I say, can I require that he be tested after an offer?
You don't have listed that that's part of your employment process.
Oh, okay, I see what you're saying. What was that? Who said that?
So you're basing having the question being, can I drug test and post-offer based on our reasonable suspicion part of our policy?
Basically, that's the question. What do you think?
We have enough reasonable suspicion, plus the reasonable suspicion is supposed to be for our, so you're for our employees after the hire.
Well, here's how I would answer it. And I'll admit right off the bat that I think it's a close question. I would say yes, but what I don't have in the fact pattern is, when was this interview? I mean, if this was a year ago, I certainly wouldn't have any current basis. If it was yesterday, maybe then I can get into having some reasonable suspicion. My point of view would be that it does give me some reasonable suspicion that he might be in violation of the policy. But in all, caution, you may not want to test. That would be one of those, how aggressive do you want to be as an employer type situations. let's transition. I see I've got just a few minutes left here. So let's talk about drug and alcohol policies. Now, you may continue to prohibit, keep marijuana as one of the prohibited substances in your policy. As we talked about, there's no requirement to accommodate the medical use. Personal use laws do mean that you're going to have more applicants who are users and more employees who are users, but it doesn't mean you have to change your drug policy just because you know that is a fact. I do think, even though you don't have to change your policies because of either the medical use law or the personal use law, that you do want to review your policies, both in relation to the Measure 91, but also more generally. One thing that I notice when I look at policies is I'm not always clear what it is the employer wants to accomplish. And I think as an employer, you need to have a clear vision as to what it is you want to accomplish with your policy. You want to state clearly what you're prohibiting, what kinds of testing will be done. You want to make sure that any key terms aren't ambivalently described. So you want to make sure that your policy says what you want it to say. And I always like to specifically address medical marijuana to highlight that, we're not accepting this out. Now, with positions that are safety sensitive, I think you want to have some clarity in your position descriptions. So, I can look at a position description and there's something in there that tells me either that it is safety sensitive or there's enough information in there to support a conclusion that it is safety sensitive. I think that training for supervisors and on up is key. These issues, whether to test somebody, and what to do when you have reasonable suspicion, what is reasonable suspicion, what to do when you have reasonable suspicion. Everybody in the chain needs to be well versed in that. You don't want to stumble into, some kind of potential liability situation just because of a lack of training or an unfamiliarity with how to operate the policy. So, concluding remarks, pay attention. The law is going to keep changing. I think it's not going to change in the key way that you can still have your drug and alcohol policy bar the use of marijuana. Continue to read the Bullard Edge. We've done 7 marijuana blog posts so far, and they will continue. And contact us earlier rather than later. So with that, thank you for being a great audience, and I'll turn it over to Adam.